welcome to LawWiser. We all have been tracking the recent updates that's happening in the taxation area. There have been, a lot of buzz around the GST Council meetings with respect to Section 194R in income tax, and a lot of recent circulars have also been brought in by the government to provide clarity on various issues. So today we would be discussing some of these important developments that have been taking place, in this entire taxation area. And to discuss this, we have an expert with us. We have Mr. Jatin Arora. He's the tax partner at Phoenix Legal. Thank you, Jatin. Thank you for taking the time out for us today.
Thank you, Sania. Thank you for having me here. Indeed, Sania, various changes have happened over the last 2 months in the taxation field. And I would say that few of the developments have far-reaching implications for businesses and also for people like you and me. So let's discuss some of the important ones, which are impacting everyone. I'll start with the recent circular that the government has issued to clarify the taxability of the penal charges, which are in the nature of liquidated damages, or the notice pay recovery, or other charges levied by banks, or they come in different forms. There have been a lot of confusion and a lot of discussion and debate on what should be the taxability of these transactions. Now, the government has issued, three circulars on various matters. We'll talk about all three of them one by one. The first, which is related to the applicability of GST on payments, which are kind of penal in nature, as I said. There was a lot of controversy around them, whether these can be said to be the penal charges which are collected by companies are a consideration for a supply of a service or not. Various notices have been issued by department to various companies, contending that this is a supply of service squarely falling under the scope of entry 5E of the Schedule 2 of the CGST Act. Now, what does entry 5E of Schedule 2 says? It says that any activity which is in the nature of agreeing to the obligation to refrain from an act, or to tolerate an act or a situation, or to do an act, that would be considered as a supply of service, and tax should be levied on that. To clarify the confusion around the scope of this entry, this circular has been issued. Via this circular, the government has clarified that there are various different situations which have been envisaged in the GST law, but broadly there are three limbs which are covered in this entry 5E. First is in relation to the agreeing to the obligation to refrain from an act. The second is agreeing to the obligation to tolerate an act or a situation. And third is agreeing to the obligation to do an act. Now, these are the three broader limbs which are envisaged by the law in the scope of this entry 5E in Schedule. And while clarifying on what should be considered as a supply of service under these three limbs, the government has said that the payments which are broadly in the nature of prevention of a breach of contract, or are provided in the contracts merely as a deterrent to prevent the breach of the obligation under the contract, should not be considered as a consideration given for a supply, and therefore should not be subject to tax. To illustrate on this aspect, they've given some explanations, and they have dealt with various situations related to examples in relation to the liquidated damages in a contract, and why these are not consideration for any supply of service. Another important point that they have covered there is in relation to the notice pay recovery, which is generally done by the corporates in case a particular employee is leaving the organization without completing the notice period, or wants an early exit. On that also, the government has said that there is no supply which is coming in picture there, and therefore there should not be any taxable event coming in that. Again, they've mentioned about the check bouncing charges, penalties which are levied by the statutory authorities in violation of the law, wherein they say that when there is a penalty which is envisaged in a law for violation of that particular law, it is not something that can be treated as a service situation being supplied by the government while charging that penalty, because this is to prevent the violation of the law. Again, forfeiture of the earnest money deposit by a buyer in a contract for sale for immovable property, etc., wherein maybe the buyer does not honor its commitment, and the seller who has accepted the advance or earnest money forfeits that because of the breach of that contract. So the government has clarified that in the similar situations, no GST should be levied, because these are not the situations which are envisaged under the scope of Entry 5B of Schedule 2 of the GST Act. It's an important clarification, but on the other, similarly, going along with these clarifications, the government has also clarified on certain situations which are actually envisaged under the scope of Entry 5E. And on those aspects, they have said that these are kind of situations in which the GST should be levied. Though again, there are various views which have been expressed about those clarifications, but nonetheless, we are discussing about those clarifications which are mentioned in the circular. The circular, also talks about certain situations like the non-compete agreements or the penal charges which are levied by maybe the travel houses or the airlines or event management companies in relation to cancellation of the bookings done by people. Maybe related to the last-minute cancellation charges which are charged, or the entire amount which is forfeited in case of a no-show. In these type of situations, the government says that these are in relation to the supply of the service, and therefore GST would be levied on all these activities. As I said, that this is an important clarification that the government has issued on this particular topic, and this has been a long-standing contentious issue for various companies. It will bring a lot of clarity in relation to how the taxable event for these situations should be treated and handled by department as well as by the businesses. Another important point here is that because this is a clarification which has been issued by the government on taxability of such situations, this should apply to all the past cases wherein the notices have already been issued by the department to various companies, and those cases should be now decided accordingly in light of this clarification by the government. So it's a huge relief that the government has brought to the industry. Now, the other two circulars, which have also been issued on the same day, on 3rd of August, broadly, the government has provided the rationale behind the decisions that were taken by the GST Council in its 47th meeting, which was held in June, 28th and 29th June. There are various decisions that the government has taken in that meeting in relation to whether the revenue augmentation or trade facilitation. And these two circulars basically talk about the decisions, the rationale behind those decisions. So we'll talk about some of the important ones as we move forward. So let's talk about the revenue augmentation measures which have been taken by the GST Council in its 47th meeting. Some of the important decisions that the Council has taken. The first one is in relation to, levying 5% GST on the non-ICU rooms of the hospitals. And this 5% GST has been levied on the non-ICU rooms in hospitals, which are above 5,000 per day charge. And there is no input credit also available to the hospitals in relation to this GST. Now, one can argue that the impact of this change will be limited to few large hospitals and not really a common man issue. But definitely, this is an important, I would say, decision which the council has taken, because till now the healthcare services have largely been considered as non-taxable, and yeah, the government has refrained from entering the healthcare side for collection of taxes from them. But this particular decision, I would say, we can look at it as a first step by the government to enter into the healthcare side and see, try and find out areas wherein they can levy tax and still keep the primary aspect of healthcare service being out of the ambit of GST by way of an exemption. Um, Second point is that uh, whether and that's a legal point in respect of whether this whole healthcare service which is provided to the patient, uh, if it is said to be a composite supply, can the government now break that composite supply into various elements and take one aspect out of it and say, I'm just picking the room rental out of the entire composite supply and leaving tax on that. We have seen the decision of Supreme Court in Mohit Minerals case, wherein the levy of IGST on ocean freight was struck down only on this point that there is no mechanism provided in the law wherein the government can actually break the composite supply and try and levy tax on one of the components of it. The second, the important decision that the council has taken is in relation to the renting of residential dwellings. Residential dwellings or residential units or flats, as we in the normal language say, were exempt till now from the levy of GST, irrespective of the fact who is the person who's taking it on rent. But now, what the council has decided is that they have rationalized this exemption available to the renting of residential units. And they have said that if the renting is done to a registered business entity, then there will be GST which will be levied on that. Now, this tax is applied under the reverse charge mechanism, and therefore the recipient who's taking the residential unit on rent or on lease, as we may say, will have to pay this tax under reverse charge. Now, this is again an important decision the council has taken, and this change or this decision will not have an impact only in the GST side for a company, because it will not only increase the cost of leasing that the company will take for its employees, but it also has some ramifications and implications under the income tax side. We know that generally companies, and especially the multinational companies, take residential flats or houses, maybe villas, on long-term lease for their senior employees or for the expat employees. Now, there are situations wherein the flats or houses are also taken in different cities, which are not for a long-term stay of any particular employee, but are mostly used as the visiting employees' guest house, so that they have a place and they don't have to go into the hotels and all. But there is a company-operated residential facility available, wherein for one night or two night, if a person, a salesman, or anyone is traveling to that city, they can go and stay there and do their work, and there is no cost which they have to incur in terms of a total stay. Now, all these were till now exempted because these were nothing for residential purposes only. But now, from 18 July, all these are now taxable. Again, the point is that the ITC of this GST, which will be paid by the company under the reverse charge, could become a contentious issue again in respect of whether this is a business expense or whether this is an expense for the personal consumption of the employees. Again, the companies from the income tax perspective will now have to relook at their arrangements in terms of whether giving the houses to senior employees on company lease would be beneficial, or whether they should now look at giving them housing allowance as part of their overall CTC. because there are tax implications also on the benefits and perks which will be coming under the income tax. Now, this is an additional activity or additional transaction on which the compliance will have to be done under income tax. The third, I think the important one, which is again the most talked about one, we see a lot of action both in Parliament and on the roads on this particular decision of the Council. This is in relation to the pre-packaged goods on which now the 5% GST has been introduced. What the government has done is, and as we know that pre-packaged goods which were bearing a brand name and there were certain conditions which were prescribed in the GST law, and if they were fulfilling all those conditions, the 5% GST was already there on the pre-packaged goods. But some, one category of pre-packaged goods was not taxable, and that, as per the government, was leading to revenue leakage. Now, what the government has done is that they have amended that particular entry in terms of the taxability. And what they're saying is that all prepackaged goods, which are fulfilling the conditions which are prescribed under the Legal Metrology Act in relation to the retail packages which are prescribed in the Legal Metrology Act, all those packages will be now subject to the levy of GST at 5%, irrespective of the fact whether they have a brand name or the brand name is registered or not. So all those, the situations which were leading to revenue leakage, the government has tried to plug those loopholes by bringing all prepackaged goods conforming to the norms of Legal Metrology Act as a retail pack under the GST Act. As we know that the underlying condition here is that the prepackaged goods should be liable to carry the specified declarations which are prescribed under the Legal Metrology Act for the retail packs. In other words, we can also say, and we are seeing this, the government has also issued detailed guidelines on this aspect, how this levy will, get implemented. And they've clarified that if a prepackaged product is not, considered a retail package in terms of the Legal Metrology Act, by way of examples, also they have mentioned that if some a particular package is above 25 kgs or 25 liters in the volume or weight, then the GST will not be levied, levied on such packaged products. And also the goods which are sold in the loose form, the pulses, the cereals, the rice, the milk, curd, lassi, whatever has now come under GST ambit as prepackaged goods. But if they are still sold on in the loose form, there was no GST earlier, there will not be any GST today also on that. The FAQs that the government has issued are also, quite clear in terms of what are the preconditions and which all type of prepackages will be subject to GST. So I think there is a lot of clarity on the point that how this tax will be implemented. But yeah, on the other aspects of this levy, I think we'll not comment on that in this segment. Now, in addition to these broader and larger revenue augmentation measures, there are other important ones also, which is that the hotel rooms of up to 1,000 rupee per night, which were not subject to GST till now, are also brought under 12% GST. The checkbooks and the loose check leaves, which are issued by the banks, which were also not subject to GST earlier, are now subject to GST. There are various other measures which have been taken by the government in relation to tax rationalizations and tax rate changes or withdrawal of exemptions on various other activities, or increase in the tax rate of various products and services in relation to the augmentation of revenue for the governments. So these are largely the tax rate changes, the revenue augmentation measures that the council has taken. Coming to the other important development that has taken place in the tax side, which is actually in the income tax regime, income tax side of the tax law. With effect from 1st of July, a new section has been introduced in the Income Tax Act, and this is Section 184R. Now, what does this section say? This section provides for deduction of the tax at source on the benefits or perquisites which are provided by an Indian tax resident to any person in India. There are few aspects related to this section which are very important. This levy or this new deduction requirement is proving to be a very cumbersome activity for some industries specifically. The scope of this section, as I said, is that any person who is providing any benefit of perquisite of more than 20,000 in a year. So the value of that perquisite should be more than 20,000 rupees in a year. That person has to withhold the tax at the rate of 10% on the value of the benefit of the perquisite that has been provided. And again, this has to be deposited to the government, at the time or before providing the benefit of perquisite. In terms of Section 184R under subsection 2, the government, has issued a clarification which contains detailed guidelines in relation to as the heading of or the title of the circular says, for removal of difficulty in implementation of this section. Now these guidelines, since have been issued in form of a circular, these are said to be legally binding on everyone. And in these guidelines, the government has dealt with various situations and provided clarity on how this whole section will be implemented, and in which all situations the deduction has to be made by the person before providing the benefits or perquisites. One specific illustration, and which is of a great concern for especially the pharmaceutical manufacturing sector, is related to the distribution of free samples by the pharmaceutical companies to the doctors. And by through that illustration, the government has kind of provided that therefore the free samples which are given by the pharma companies to doctors are also to be considered as benefits or perquisites arising to those doctors, and therefore tax has to be deducted at the time of provision of these free samples to them on the value of these free samples. Now, how the value will be determined, again, I think there are different views on that, and this could lead to some litigation in the coming days on this aspect. What should be the right value of the free samples that is given? But the first, I think the important point here is that whether the free samples which are provided to the doctors, whether they can be considered as a benefit of perquisite to the doctors. Again, the point is, we know that how the industry works and why they provide these free samples. It's more from the purpose of doing a promotional marketing activity of the products of the company. And mostly the idea is that when these free samples are given, the doctors may again further give these medicines on free of cost basis to some of the patients, and will kind of collect the data in terms of the efficacy of this medicine, or what is the side effects, or what is the period of the treatment that a patient has to undergo, and that report is then generally shared in the form of comments by the doctors with the companies. Now, who is the beneficiary in terms of these free samples being given by the companies to the doctor? And because these are not for sale free samples, how the doctors will get benefit out of it? We have seen the development of this TDS aspect, and we know under Section 28 what should be the situation, or what should be the event for deduction of the tax. And as per the judicial precedents and how the whole concept has evolved, the understanding is that it should be on income arising in the hands of the recipient. Now, how the free samples which are not for sale, which the doctors do not require actually to do their practice, and they are not under any obligation to receive those samples and give it to the patients, how these will be treated as benefits or perquisites, I think we'll have to see how this whole concept will evolve, whether the government will come with further clarifications in the form of guidelines to remove the difficulties in implementation of this section, or whether these matters will reach to litigation and get settled there. We'll have to wait for that. Thank you. That's all from my side on this.
Thank you, Jatin. Thank you for all those updates. Thank you for sharing with us.